webinar will begin shortly. Please remain.
World. I am Ashish Kothari. I am representing Atmiya Institute of Technology and Science, and we are situated at Rajkot, Gujarat. Basically, today I am talking about the patent filing procedures that is to be followed in India, specifically in India. Right? There are various countries where you can file the patent, but today I am talking about how you can file the patent in India and what are the procedures of following the same. So, as you can see, I said patent. Basically, it is a techno-legal document uh, because it is a document where technical document where some legality can be added by the Patent Office India, so that the entire rights goes to who files the patent. So today I am going to talk about basically how you can file the process patent, who can file the patent, and what are the timelines for filing as well as getting the patent from India. So basically the first question arises in mind is patent, what it is. So basically it is a techno-legal document and it is a grant of exclusive rights to the owner of the patent. Means if you have an idea, as I have explained in my brief, that if you have an idea, if you have invented something, or even if you have some logic in your mind, you can go for filing the patent. And once you get the patent, it stops others from making what you have idealized, using or offering for sell. One cannot sell or import the patented invention without permission of the owner. For example, I have an idea and I filed a patent in Indian office, then Indian Patent Office. Then after I get the patent, or before the procedures of applying the patent and getting it from Patent Office India, I can legally stop others for making the same kind of concept, using the same kind of concept. One cannot offer for the sell what I have documented, or one cannot import from the another country the same idea without the permission of mine. This is what is the idea of why I should file the patent and what patent is. So as I said, it is a techno-legal document and it is a grant of exclusive rights to the owner of the patent. So this exclusive rights are given, so far as India is concerned, this exclusive rights for using your patent is 20 years so far as India is concerned. Basically, if you have the patent, you can use that patent document or that exclusive rights so as to build your business. You can rent your patent, that means your idea or your process or even your instrument which you have invented, to existing business owner. If you cannot start your own business, you can also rent your idea, your patented process or your patented instrument. You can also you can completely sell the patent to the other company. For example, so far as pharmaceutical is concerned, in majority of the cases in pharmaceuticals, major of the patents are sold to the big companies, rather than the patent owner start their own business. So this is what happens, and this you can do if you have the patent rights, and this you can do up to 20 years so far as the Indian Patent Office is concerned. So why should I file the patent? The only motivation is I can earn the significant amount of money for in-demand invention. That means you have an invention, you make it for the society, and if it becomes sellable, then you can earn the significant amount of money. And there are number of examples with us that has a small idea in their mind, and they are billionaire now after filing the patent and after getting it from the Indian Patent Office. So eligibility, so far as the eligibility is concerned, there is no such eligibility, but you can be a business owner. You must have an idea first. That idea may be that idea may be conceptualized, or that idea may be implemented so as to make an instrument or a device that can be sellable or that can be used in the social background, right? You can be a business owner, you can be research scientist, you can be professional, you can employee, or you can be a student, right? Or you can be anyone. These are the four things that I have written, but basically it is not the only business owner or research scientist or professional or student can file the patent. Anyone who is having Indian nationality can file the patent in India, right? Even if he or she does not know how to write the patent document. In front next slides we'll see how they can be able to do that, but basically anyone who is having the Indian nationality can file the patent, right? If he or she has a good idea or good inventions being done by him or her. So basically eligibility is Indian nationality. So basically patent filing procedures can be done either alone or jointly. um, you must be the first inventor. This is the first and foremost requirement of filing the patent application in India. You must be the first inventor of the invention that you are filing, and you must be true also. By the meaning of true means you must have those idea clicked into your mind, and you have verified that your idea is not implemented yet. Or you can be true and first inventors assignee. For example, I invented something, but I don't know how to write patent application and something like that. I how to communicate with the Patent Office India. I don't know that. Then I can assign someone on behalf of me. He or she can communicate with the Indian Patent Office so far as my invention is concerned, because I don't know how to write the patent application. There are major inventions coming from the rural background wherein the literacy rate is very low. But even if that a low lit that means literally low level person can also file the patent on behalf of him or her. Someone can file the patent who can communicate with the Indian Patent Office. Or third, you can be a legal representative of the deceased true and first inventor on his or her assignee. There are patent attorneys available in India, where you can go, you can take and help from them, and you can file the patent. True and the first inventor, as I said, as I written, true and the first inventor does not include the first importer of an invention into India. So basically I import something from the other country and say that and decorate the same in Indian style, and then I can patent. This is not the way, right? The examiners know that. And you cannot be a person to whom an invention is first communicated from outside India. For example, I am here and I have a very good friend outside the India. He communicates to me that this can be done, and I can, and if it is not my idea, I cannot file the patent, right? So this means that you must be true and the first inventor. uh, so far as the jurisdictions is concerned, the address of service, there are four patent offices in India, residing in Delhi, Kolkata, Chennai, and Mumbai. Depending on where you stay in India, you can take the services from various patent offices in India. For example, we reside in Gujarat. Hence, we need to communicate with the patent office Mumbai. Similarly, some cities and some rural are associated with Chennai, Kolkata, and Delhi. So before filing the patent, you need to have an idea that basically I need to communicate with which patent office. But from all this is for administration work, but patent filing procedures is commonly assigned the common examiners after you file the patent. So basically there are four patent office: Delhi, Kolkata, Chennai, and Mumbai. When you file the patent, basically it reaches to Controller General of Patent Office. From that it goes to the to joint controller, deputy controller, or assistant controller. There are three sub officers from that, and that they decide the panel of the examiner based on the subject matter with which you filed the patent. So your patent application goes to the patent office, and from that patent office it is decided that which panel of the examiners is suitable for you after your patent or application gets examined. So this is the very important web page for information of various rules and various sections of Indian Patent Office. Basically, it is ipindia.nic.in, where you can go and you can find the detailed information of how you can file the patent and what are the procedural aspects of various stages. Um, uh, Filing the patent application in India means what? So basically, Indian Patent Office says that the question arises is when to file. So Indian Patent Office say that as earliest as possible, because Indian Patent Office follows first to file system. What does it mean? It means that, for example, I have an idea, and another person in India have the same idea. What I do is I wait for I have an idea, I wait for idea to be implemented and make a product, and the other person does not wait for the idea, but it files the patent application once he has the idea. Now what happens is, even if I complete the I complete the same idea, I complete the same product before him, I cannot be allowed to manufacture those products which is being filed only by the second person. So the Indian Patent Office says that you must be as early as possible so as to file the patent application. You must be first to file, or patent office follows first to file system, right? So the question arises, in the next slides we will see that types of the patent application, and you will come to know that yes, I should file first, even if I have an idea only and I am not sure whether that idea is to be it can be completed and can be can be converted into product or not. Even if you have the idea, you can file the patent and then you can work on that, and then when the work is completed, you can inform patent office that my work is completed, and then you can go. So what to file? So basically invention is the thing that you can file. Invention means that means before 2003 the definition of the invention um, from the Indian Patent Office was different, but after 2003, invention means a new product or a process that involves the inventive steps and capable of industrial application. Basically industrial application means it can be suitable to the industry, it can be suitable to the social innovativeness. So basically if you have an invention which creates an easiness or which provides an easiness in the current procedure, then you can file the patent. So invention means what? So invention is a fundamental research or an improvement on existing art. You can solve unsolved problems of the art or unaddressed issue or different approach. For example, we have filed a patent of a pen which can read. So for example, we had an idea in Atmiya, we had an idea that if a person cannot see, right now today a brain lipi kind of concept comes. So a person who cannot see must have the hand to see or to read from the brain lipi kind of concept. But suppose a pen has an eye and it can read, that what happens? Then we file the patent that a pen that can read. So pen can be used as for writing. The same pen can be used for the reading also. So this is what we find, that the pen is existing art, but the problem is pen can write. Now we find not, if the brain lipi, the concept of the brain lipi is somehow to produce the brainlipi document is costly, and if I want to read that, that must be special. But with our invention, what we can do is we can have a camera inbuilt, a small camera onto the pen that reads the English letters or Gujarati letters, whatever it is, and converts it into audio using the inbuilt microprocessor that we have fit inside the pen. So basically, this is somehow you can address a local issue or a global issue, and you can file the patent. So you must have a different approach of utilizing the current invention. Um this is how you can go for filing the patent. Before drafting of the patent, you must solve these questions. That what is your invention? Basically, this is the most important question: is your invention patentable? How would I come to know that this is my invention, and is it patentable? Is invention novel, inventive? uh, so basically, these are the questions that I must have the answer of before I file the patent. I should go for the prior art or prior disclosures before I file the patent. It may be oral disclosures, it can be printed publications available to the public. I should read that, and prior public use. So the thing I cannot publish, the idea that I am going to publish, or the I am going to patent, um, should not be such that it is already available, or it is somehow orally disclosed, right? So before drafting, I should have the answers from these questions. So before the drafting, I should verify the following. You must conduct the search, means it can be a Google search, it can be Google Scholar search, and there are many websites where you can find the already available contents or already available patents from your search. You can enlist problem in the prior art. That means, suppose we have thought of designing an easy system to read. So the problem in reading is that brain lippy concept. Then we have thought of putting a camera onto it, and taking the images out of it and reading the images. So basically, what is the problem sought to be solved by the invention? So this is the problem that needs to be solved by the invention. What is the novelty? Novelty is the pen that can write can also read. Is the solution obvious? Do you find that it is an obvious? Is it an artificially excluded? Basically, is there any publication that gives the idea of this kind of invention? So you must see that this questions, or you must verify these, basically this all sort of issues. Uh, there is a list of what you can patent or what you cannot patent. That means what is patentable and what is not. So Indian Patent Office gives a list of what you can patent and what you cannot. Uh, the Some thing that you cannot patent is being written over here, that inventions that cannot be patented are opposing to well established natural laws, right? The laws which is well established in nature, you cannot oppose, and you can file the patent. Scientific principle or abstract theory in a different manner, you cannot patent. A new property or use of a known substance, no. If you can mere mixture and process thereof in synergistic mixtures, you cannot. Method of agriculture or horticulture, you cannot. Means essentially biological processes, it is not. Why? Because suppose haldi, that was patented in US, but after some cases, a case was filed in US that haldi cannot be patented because the Indian Ayurveda system was using those haldi in already in various places or various purposes, and hence US Patent Office has also US Patent Office has declared that the natural things cannot be patented, right? So the things that are not patentable. Now the most important question: kind of specifications. So patent applications are of two kinds. One is provisional, one is complete. As I said earlier that Indian Patent Office says that basically you need to be first to file the system. When I have the idea, I must file the system. But I have a doubt that whether my idea is to be converted into product, or it is to be converted into product as my idea is. If you have the doubt, you can always file a provisional patent application. When provisional application must be filed when there is an urgency. That means you know that yes, I should file the patent right now. I should go for my idea and I will complete it within a specified period of time. Um, um, Before the submission of the thesis, inventors or seniors leaving the company, or accidental disclosures, and many competitors. These are the various facts with taking care of which we should file the provisional application. Once you file the provisional application, you are assigned an application number, and Patent Office India allows you for 12 months. That means after you file the provisional patent application, you are having 12 months so as to complete or convert those ideas into product. In between that, if your idea is deflected somewhere and your product is not equal to what you have described in provisional application, you can always file a complete application wherein you disclose everything what you have done. You have your product in, and you can claim for some basic points. For example, we claimed for this camera operation, we claimed for the use of the microprocessor inside the pen. So when you file the complete application, basically it is complete in all aspects. Means you file the technically complete application. It becomes now techno-legal document. You must write claims for which you are filing the patent. You need to give the complete description of the product which you have designed. Complete means completely describe. So Patent Office India gives you the idea that whenever you give the complete specification, you must disclose each and every small things that you have designed into your product. As means if you are not giving some information, the time period that you can go for will be increased. So Patent Office says that you must give each and every little thing, minute thing that you have included in your product, and it makes sure that it is not disclosed other than the Patent Office Mumbai, sorry, Patent Office India. So these are the various forms that needs to be filed whenever you file the patent. The first is application of grant of patent, wherein you said about yourself. That means you can be an inventor and you can be an applicant. These are two different names that you will like to write down in form number 1. Means there are two options. You can be inventor, and the same can be applicant. Now the patent rights by the Patent Office India is given only to applicants of the patent, not inventor of the patent, right? So what happens is in some companies, inventors are basically the person who are working in R&D department of the company, wherein the applicant is company itself. So what happens is when the Patent Office India gives the rights of patent, it gives the rights of patent to applicant. That means company. And company, based on what amount or what revenue is generated after the patent is granted, decides that which what portion of the revenue is to be given to the inventor. Point number 2 is or form number 2 is complete or provisional specification. Means as I discussed earlier, you can file provisional patent application, you can file the complete specification after 12 months of the provisional application. Similarly, form number 3, form number 5, declaration as to inventorship and statement and undertaking under section 8. There are, and if for example I am giving all my rights to assignee, I should file form number 26, that is power of attorney. And when basically in the next slides we'll see the timeline, and in the timeline we can see that form number 18 is most important, request for the examination. And patent office India is charging some fees. We'll see in the next slide that what are the fees for various parts while we file the patent. Provisional or complete specification. Basically form number 2 is very important. Form number 1 gives your information about inventor and applicant. Form number 2 gives the information, complete information about the patent, about the product, right? Starting from the title to the technical field, background, current problem or the gap which I have found, solutions of the problem, summary. Detailed description is most important. Detailed description means detailed description. No minor portion should be taken out. Every minor point should be disclosed in the detailed description. Experiments, trials or examples what you have taken out. Claims which are not required in provisional but they are must in complete specification. Abstract, and if you have a drawing you can also file. So basically title is a concise statement providing a crux of the invention. For example, a pen that can write. So your title should not be so little, or your title should not be so big. So it can be between 10 to 15 words or like that. Your technical field should give you more details than the title. That means my field of invention is, or the field of this invention is, for example, automation. The field of this invention is pharmaceuticals, like this. It provides the utility, as well as sometimes it is used as a tool for search in the absence of the abstract. If I am not clear from the abstract, I can use the technical field so as to find the more clarity. Background or prior art, that means before I write down the patent I should go for the background, I should go for the prior art, and based on the prior art I can find out unsolved problems, prior art solutions if they are not working, and describe new solutions adequately. That means prior art, background and prior art is very important. I should go back, I should see that no inventions is like me, or I am giving new solutions of whatever is already invented. So after identifying the current problem or a drawback and gap, you can give the solutions to the problem in inventor. You can summarize in the invention, and then, as I said, you must give detailed descriptions. So basically it sets out the best mode of performing the invention, that how you can perform. You can have the point at which you can describe the your patent, that means your product, and like this. Claims, as I said, not required in the provisional specification but must in the complete specification. It is the operative part of the specification. Basically defines the monopoly to be conferred by the patent. Basically, so I have invented the pen. Basically I not invented the pen. Claim is not to be done for the pen because pen is already there. Claim is to be done for the capturing of the image from the camera. It goes inside the pen. It is being processed by the microprocessor, converted into speech, and gives the idea to me that this is what is being written in that particular part. So I must claim for those part rather than claiming for the entire pen, right? So this is what the claim means. And then abstract as well as drawing, if any. So these are the various stages of filing the patent application in India. I filed the patent after before 12 months before that means, suppose I am filing the provisional application. After filing the provisional application, in 12 months I should file the complete specification. Patent Office India gives me 12 months of time to complete my idea into product. So after filing the provisional patent application and filing the complete specification, after filing the complete specification, 6 months after filing the complete specification, it is being published. Your patent is published in the public domain. Every Friday, Patent Office India on every Friday publishes the documents depending on 18 months of completion. So I filed the patent today, and after 18 months my patent will be published in my in Patent Office India website, IPC India website. But it does not mean that you have that patent granted. It is only published, right? After the patent is published, you can request for the examination, and therefore you need to file a form number 18, which was being written in the previous slide. So you must request for the examination. After you request for the examination, in between 6 months, your first examination reports comes, and in first examination report, the examiner gives you the idea of whether need to submit something or modify something or like this. After you submit the response, then that that based on your response, further examination is conducted, right? Then hearing is done. You can be granted, the patent can be granted or patent can be refused. So this happens until the examiners are happy with the what work you have done, right? Now what happens is, in Indian Patent Office, suppose I have requested for some examination and someone else knows that this particular patent has been published. Now before the examination, pre-grant opposition can be filed by someone else. That means someone else can oppose that no, this invention cannot be this invention cannot be granted patent. So someone can oppose B. If someone opposes B, that examination report can that examination committee cannot grant or refuse my patent based on before the opposition is cleared, right? So pre-grant opposition can be done by anyone after the publication before the grant, right? So suppose there is no pre-grant opposition and I am granted the patent application for 20 years after the examination report has been successfully done, and after it is granted, that grant is being notified to me. Now after this grant is notified to me, as well as that patent is being published in the website of IPC India, even after that, Indian Patent Office says that even after that one can file the post grant opposition. If I am being granted a patent, someone can refuse my, that means someone can oppose that this patent cannot be given a grant because the, there's a problem at this particular point or something like that. So after the opposition, finally again the appeal is filed and granted or refused. Then one time you can have, suppose pre-grant opposition is rejected, then finally you will be granted the patent application for 20 years, right? So this is what are the stages of various stages of patent application. The problem with patent applications in India is it takes more amount of time, but from last 2-3 years the patent office CIS of India started this work in hurry so that the maximum majority of the pending applications gets cleared. So basically these are the patent procedures in India, right? This is what we discussed. So far as the patent fees are concerned, you can see that the first application for the grant of patent for the natural person, there are two kind of filings. If you can see, there are two kind of filings that you can do for e-filing, and you can file a physical file. E-filing is suitable to those who are filing the patents in a year. They are filing 20-30 patents in a year, because e-filing requires a digital signature, and digital signature itself is somehow costly. So if you are not able to file more than 20-30 patent applications in a year, my suggestion is to go for physical filing. So for physical filing, the patent application fee is 1760, right? And for when you are paying this fees 1760 for the complete application, the patent office says that you cannot uh, go beyond 30 pages, and you cannot go beyond 10 claims. If you are going beyond 30 pages, for each page you need to pay 176 rupees extra, and for each extra claim then 10, 352 extra. So this is one time fees only. Then form number 2 does not require any fee. Form number 3 does not require any fee. Form number 4, application for the request of extension of time. Basically, suppose I filed a provisional application and in 12 months of due time I'm not able to convert it into product, but I know that I can convert it into the product after 3-4 months. So per month there are amounts that I can pay. Being a natural person, I can pay 528 rupees per month so as to apply for the extension of the time, right? Then there is a form number 18, suppose form number 18, that you can go for a request for the examination, and it requires 2500 rupees, right? So the total cost of patent fees, if you are filing the patent alone is 1760 plus 2500. This is the only fees that you need to pay if you are in time. So patent application in India does not cost much. Basically it costs less than publishing a paper, international paper in some conference or somewhere like that. So my suggestion is, if you have an invention, file the patent rather than go for uh, publication in journals or somewhere like this. So once you file the patent, these are two snapshots which I have got after filing the patent. So the first snapshot is patent filing acknowledgement that comes from Patent Office India, and second is published in the public domain. So when it gets published, so abstract along with total number of pages 14 and number of claims are 10. So this is what the patent office gives to us, right? So this is what happens when you file the patent and you go ahead. There are number of types of patents on which we can discuss later on. Ordinary applications, basically it is a complete application that you file. Then you can file the convention, PCT application, national phase application, patent of addition. For example, if you have a patent and if you are adding something to that, you can file the patent of addition. You can file the patent of divisional application. Then patent filing strategies are, you can go for only national filing. That means in from India you can file in India. You can file the conventional filing of the in US or Europe. You can file the national plus conventional countries. You can file in all three countries. You can file the PCT application. This is most important, PCT application. In any of all 146 countries, sorry, states, countries, you can file the patent applications after filing the patent in India, if you feel that you are able to crack that, right? So this is what I was being trying to say in patent filing strategies and patent filing procedures in India. I acknowledge the work from Atmiya family, and I thank you all for patience listening. I thank you Sridharan sir, um, who have helped. So thank you all of you for patiently listening, and I can invite answers, uh, questions, so that I can give the best answers. Sir, hello,
Yes.
any question,
Can we
sir?
patent? Yes. Can we patent computer algorithm which is better than currently existing one?
Uh, uh, Pardon, sir?
Can we patent computer algorithm which is better
Uh,
than a currently existing one?
uh, Computer, basically Indian Patent Office does not allow you to file the software patents. Software cannot be patented. Computer algorithms cannot be patented. Only the physical components, so far as Patent Office India is concerned, only the physical instrument or device can be patented.
Why patent drafting has been so difficult in India as compared to US?
Basically, patent drafting is not difficult, but amount of time that is required in between drafting and having the patent is very high. That means basically I filed my first patent in 2012 and I am not able to find my examiner panel yet. So it is a 5 years time from which I have not get the examiner's pattern even if I'm going in time. So this is what is basically there are number of examiners that are less in Patent Office India. I feel that. So filing the patent application is not difficult, it is so easy, but the amount of time that is required by the patent office, that is taken by the patent office, is very high. So uh, for example, I filed the patent today and after 5 years I am not getting that. So in 5 years the technology is changed. So this is what happens. The procedure is little bit uh, time consuming. This is what. Otherwise, patent filing procedure in India is simplest one. Sir.
How many have your college filed?
Okay. So far as Atmiya Institute of Technology and Science Rajkot is concerned, we have filed 38 patents from year 2012. And
What are
as I said,
good, sir.
and yes, sir.
Yes, sir. Continue, sir. I thought it was over.
Ha, ha. Basically, as I said, in 2012 we filed the first patent. We paid for request for the examinations, but since that I am not able to get the examiners panel communicate with me. So time consumption is the main problem of patent filing process. We filed 38 patents in different domains of engineering, and in most of the patents we go for the multi and interdisciplinary kind of products, which is socially relevant. This is what is majority theme that we follow. Sir.
What are the pitfalls in filing patents?
Um, Pitfalls in filing the patent is, so far as pitfalls are concerned, only prior art searching. That means Patent Office India does not give us all the liberty of prior art searching, or there are softwares which are paid. There are softwares which are paid wherein you can file, you can have the complete search.
Can a physical device with software be patented?
Yes, yes. If you have only software cannot be patented, but if your software is um, uh, controlling some device, and if your software is communicating with some device, or if your software is catching some device's output, then it's fine. You can patent.
If we run algorithm on FPGA kit, which is device,
Fine, fine, fine. We have filed the patent. We have filed 4 patents on running the algorithms, writing in algorithms and putting it into Xilinx kit, and they allowed it.
how can a professor file a patent of a project in which students are working?
What you can do is in the name of the inventor as well as applications, You can put your name in the last part. For example, there are two students working under you. Then there are three names, three inventors and three applicants. And the third name is of you, and you can have a deed that how much percentage of the revenue that can be divided into all of these three. That means two students and one professor. So you must have a deed in with students that after the revenue is generated, after the patent is granted and revenue is generated, how much portion of the revenue that you can have. Professor can put his or her name in the last name in applicant as well as inventor side. Yes, sir.
Are you conducting any faculty development program in this area?
Yes, sir. So basically, I have given right now up to this point, I have given 5 expert talks on how to write good patent application. Good patent application means what are the care that you need to take care in writing the patent applications. 5 faculty development programs outside AITS has been conducted under that means I am giving that.
Can an Indian file patent in other countries without filing for India?
No, basically Indian Patent Office says that if you want to file a PCT application, you can file. If you want to file, but before filing the patent in the other country, before 6 months of that, you need to file it in India.
In patent search, most of the patents are public but not checked by examiners. The status of patents are granted or filled.
It happens that if the patent is published, if this is very right question, that suppose I have filed the patent today and my patent is not published and someone else searches this someone else have the same idea but cannot find the search, then in this particular case the first to file system appears. It cannot be searched because it is not published anywhere in Patent Office India until and unless I file a complete application that cannot be published in the Patent Office India website.
Suppose you got a project from an agency. Based on the invention, can you file a patent for the invention?
Yes. Means you are means I or this is a question.
Yes, sir.
This is a question, right?
Yes, sir. Yes.
So yes, for example, some industry has done something, but they, as I said earlier, if I don't know reading and writing, or I don't know how to communicate with the Indian Patent Office, you can always give some assignee or rights to communicate with the Indian Patent Office on behalf of you. So that agency can give the complete procedure to me. I can file in behalf of them, and this way can be done.
Then who is the owner of the patent, a college or project office?
As I said, basically Patent Office India gives the patent rights to applicants. The applicants whom you described in form number 1. There are two names, inventor as well as applicants. The ownership is given to applicants only. But suppose basically there are so far as fees are concerned, natural person has having less fees. In our case, in our Atmiya Institute, what we do is all the patent application fees is being given by management, but in applicant side, Atmiya does not appear. Atmiya is not appearing. That means if the patent is granted, it is granted to the student and the staff member of Atmiya. Atmiya does not put its name. But suppose Atmiya want to put its name in applicant side, then the required fees increases to 10,000 rather than 1,760. because it comes into small industries. So the patent right goes only to applicants.
Have you licensed any patent for an industrial application?
Uh, as I said, the first applications that I have filed yet not examined, but I have filed for seven patent applications with reference to the various industries, local industries in Rajkot.
Are you having any patent lawyer to help you?
No, I am not taking any help from the patent lawyer, but there are patent lawyer, um, uh, instead of patent lawyer, we can say patent attorneys. So there are many patent attorneys in various parts of the India that can that they can help in filing as well as as well as communicating with the Indian Patent Office. There are many in in around Rajkot, in around Ahmedabad, in around Gujarat, and in around India. There are many patent attorneys that they can help.
What are the common mistakes that happen while filing a patent?
Uh, the first and foremost common mistake that happens is we don't go for a prior art search. Whatever we think that it is novel, and we file the patent. So the first and foremost thing that you must take care is you must give some time to prior art search. Then writing the patent application, we have a mentality not to disclose something in detailed description. Patent office says that you must disclose everything in the patent application so that examiners gets help while reading your patent application. They get help, or they easily understand what you are going to say. If they don't understand, they will give you that means they will ask you, and you need to give the answer then, and this requires more amount of time. So this is the second mistake or second problem that we have when we write down the patent application fee. Sorry, patent application. Third is drawing. So drawing is most important. We draw, but we do not draw very precisely. So far as the dimensions are concerned, in mechanical drawings, dimensions are most important, and if we forget writing the dimensions, this again gives a hesitation of examiner at which particular instant this can be examined. So these are the mistakes that we do while we write down the patent applications.
If we develop a new product with open source technologies, will we be granted a patent?
Open source technology software, usage of open source technology software is fine, but as I said, it must be some product, then it's fine. Open source are open source, you can use, and you can use it without problem of licensing. You can use it in any product. If that product is innovative, you can use it, fine.
How many of your patents have been granted?
No patent of ours has been granted. As I said, we are in basically in examination phases in many applications, but yet in many applications examiners has not been decided. So far as pharmaceutical patents are concerned, there are many examiners available with patent office, but so far as engineering applications are concerned, the number of examiners are less. But now patent office is trying that this procedures can be hurried up so that the pending work can be reduced.
If the technology changes, then by the time patent is granted, commercial advantage is lost. How can we avoid this?
Uh, so this is the point that I was discussing. If the technology changes, then we need to take care that even if the technology changes, your product is validated up to 3, 4, 5 years or more than that. But for 20 years, you cannot have an idea that into the 20 years the technology does not changes. So you must have an idea. For example, solar technology. If I have an idea before 7 years, since the starting of the solar technology, and if the patent office, as they said, in 48 months, if they clear my patent, 48 months means 4 years, then yet 3 years I would have an advantage. 3, 4 years I would have an advantage to make sure that my patent application gives me the amount.
Well, thank you very much, sir, for answering all the questions. And
Sir,
yes,
thank you, sir. And if any one of you have any question, I am writing my email ID uh, on my screen, and you can anytime you can have any question uh, can be raised, and I am very happy to give the answer. This is my email ID. Thank you very much for patience listening. Thank you, Sridhar sir.
thank you, sir. We'll just keep that few seconds and I will close.